It is a great pleasure to introduce my close friend and longtime colleague, Dr. Nick Teasman, who will speak today on the jurisprudence of torture in Thailand. Nick is a fellow in the Department of Political and Social Change at the Australian National University. And before turning to his exciting and groundbreaking work, I actually want to note, I think he deserves to be thanked at least 3 times, that he needs extra special thanks because it is 3 a.m., which is a time, it's not a time most people stay up until, and it's not a time most people get up. It's sort of right in that middle point where almost everyone is asleep. So we are so glad you're here. Nick Teasman is a scholar and theorist of law, politics, violence, and human rights in Myanmar and Thailand. And actually, I would say in a broad comparative sense as well. He has been lauded with fellowships from the Australian Research Council, the Institute for Advanced Study in Princeton, and the Kyoto University Center for Southeast Asian Studies. His first book, Opposing the Rule of Law, How Myanmar's Courts Make Law and Order, and actually for any of you who have taken my violence, justice, and history class in violence, justice, and history in Southeast Asia, you have read it, elegantly exposes that the rule of law is a fiction in Burma, and instead a system of law and order utterly bereft of justice has been enforced upon the people. Meticulously drawing on a wealth of Burmese language court and other records, he traces the development and consolidation of law and order over the longue durée from the British colonial period to the initial years of the post-semi non-transition from military dictatorship in the early 2010s. He has also written extensively on extrajudicial violence, impunity, and in his most recent work and the paper he will share with us today on torture. This is urgent work in Thailand, but also far beyond it and everywhere where state officials torture citizens in the name of duty. His work is shot through with the clarity that emerges from knowing that injustice is not simply something one studies within the university, but a driving force shaping and causing suffering in people's lives. Finally, and this is relevant for the Q&A, before turning the screen over to Nick, I also want to note that he is a very generous and sharp interlocutor. He asks excellent questions during seminars. For the 8 years that we were colleagues and attended the same weekly departmental seminars, what I was always struck by was his ability to discern the hidden frames and structures behind any argument presented in a paper, sometimes even frames and structures hidden to the author themselves, and to ask questions that were at once fun and inspiring to think about and also very useful to the authors. May we do the same for him today. The screen is yours.
To Mary, thank you very much for both of you for your invitation and for your generous introduction. And needless to say, everyone, I've learned a great deal from Tirul Haberkorn about the issues of state violence in Thailand that I'll be speaking to today through the research they've done there in the last couple of years. But suffice it to say that without the kinds of conversations that Tirul was alluding to a moment ago, I certainly wouldn't be in the place where I'm at now, which is still very far short of anything that would resemble a book manuscript or another form of communicating to a very wide audience, but nevertheless is also very much a work in progress. So for that reason, I'm looking forward to the conversation that follows. I'd like at the outset to do something that my undergraduate students have been urging me to do in any forum of this sort, whether in the classroom or online presently. And that's something that we do in Australia to acknowledge the fact that we're in a settler colony. We acknowledge country by recognizing that sovereignty of the Aboriginal population in this country was never ceded. Acknowledge the specific Aboriginal groups where we're located. So in Canberra, that's the Ngunnawal and Ngambri peoples, and pay respects to their elders past, present, and emerging. And the one other thing I'd like to do at the outset, just by way of perhaps a small but important administrative note, is to remark that, of course, I think you'll all appreciate, given the topic for the talk today, that there will be some detailed references, not greatly detailed, but nevertheless somewhat detailed references to instances of state violence, specifically torture on detainees in Thailand. And therefore, if anybody here is concerned that they may be affected by those narratives, you may like to stay as long as you can or reconsider participating in this event today. But I thank you all very much for coming. And I'd like to begin the narrative by going back to a mid-morning late in May 2018 at a meeting room at the center of a courthouse in Prachinburi, the provincial courthouse there, which is a few hours by car to the northeast of Bangkok. I was in that room with a number of other people that day in May 2018. And looking around, I saw that apart from an oversized wooden table and some faux leather swivel chairs, there were a few other distinguishing features of the room, but not many. One of them was behind the head of the table, an imposing gilt-framed picture of Thailand's not long deceased monarch, King Bhumibol. And in this picture, with rays of light streaming around his body, was a quote to the effect that parties to cases coming into that room ought to try to reconcile, to produce win-win outcomes rather than win-lose outcomes. So this room was, in fact, the court's mediation room, not a trial court room. It was a room in which the counsel of the former king on the wall above us served to remind all of those who were assembled as adversaries that they ought to leave conciliated. They ought to try to overcome their differences. Now, that particular morning, the room was occupied by, among others, two uniformed mid-ranking police officers, their lawyers, the wife of one of the police officers, and another officer who had come in solidarity, who sat together along one side of the table. Despite the air conditioning in the room, beads of sweat gleamed on the foreheads of the two policemen. One of them was fidgeting and his chest rising and falling quite discernibly under his tight khaki uniform. The other one sat stone still, staring ahead blankly, it seemed to me, at or perhaps right through the young man who was sitting opposite him. Up and down the table from the young man who was sitting opposite him was that young man's father, who was the owner of an auto supply store in a small town about half an hour distant. Three more lawyers representing the young man and his father, the representative of a human rights organization who had come from Bangkok, and myself. So why were we all sitting there in this room in the courthouse in Prachinburi? Well, over 8 years previously, the two policemen who were sitting opposite had beaten the young man facing them when he was 18 at that time, and suffocated him repeatedly with a plastic bag to have him confess to the theft of a motorcycle. They told him that if he did not confess, then they would kill him and dump his body on a nearby mountainside. Then they'd soon dropped the charges against him. Nevertheless, his father brought complaints against the police over what they had done to his son. The matter dragged on and on over many years, but the father of the young man didn't want to let it go. He insisted that he wanted to make an example of the police, to have other police officers think twice before they also reached for a plastic bag in order to get a confession from a detainee. Now, by the time that we had gathered in that room for conciliation in the provincial courthouse in Prachinburi, nobody present denied that the police had beaten and suffocated the teenager. In fact, two other police officers who had been present at the time of the torture had themselves admitted that the torture had taken place and put those admissions in writing. One of them had even paid some compensation to the family in order to get out of the case. So the two of us who were sitting before us, the two police who were sitting before us that day, were those two who remained because they were identified as the key participants in the act of torture. One was the lead officer in the unit that was investigating the case, and the other, on the accounts of the other police, had also been directly involved in the torture. After a few minutes sitting there silently, 4 men in suits arrived and pulled themselves into chairs at or adjacent to the head of the table below the image of the king. 3 of them, it transpired, were judges at the provincial court, and one of them had come from the next level in the judicial administrative hierarchy, overseeing courts across a number of provinces in this region of Thailand. The eldest among them, who was late in his career, had taken on the duty of assisting in mediation processes in the Prachinburi courthouse. And he was the one who took the lead initially in the conversation that morning. He urged the parties to the case to reconcile. He said that the matter had gone unresolved for too long. He said that after 8 years, the parties ought to have an opportunity to come to a satisfactory outcome for everybody involved so that they could all live comfortably and free from stress. And he emphasized the need for forgiveness. In doing so, he put the onus of getting a way out of this situation on the young man and his father, not on the police torturers, urging them to do the right thing to bring the matter to a win-win conclusion. After his initial statements and some introductions of everyone in the room, all of which was very different from the trial process, needless to say, the judges then asked everyone to leave except for the police, the young man and his father. So even the lawyers left the room initially. Then they discussed the case in private, just with the police officers, the torture survivor and his father. Over the next couple of hours, the judges pressed the young man and his father, both with and without their lawyers present, with and without the police present, to accept a compromise. At home, later in the day, the father of the young man said that the judges had insisted that the police did not intend to cause harm and that they were, after all, just doing their duty. However, what exactly transpired inside that room, we'll never know, because the court kept no records of these discussions. Around midday, the facilitator called in a female clerk, and she prepared a 1-page report to the effect that the parties were reconciled and had agreed to the police going to apologize to the mother of the young man, since she hadn't come with the young man's father to the courthouse. The judge from the region above the provincial level then pushed the parties to try to come up with an amount of money that would change hands once the apology was accepted in order to close the matter. But the young man's father and lawyers stalled, and they insisted that they would have to wait and see how the meeting with the mother went. Well, as it transpired, the mother refused to accept the apology of the police. And after a second failed attempt at mediation, the case did go to the trial courtroom after all. And what happened thereafter goes to the topic of my talk to you today. Police officers, soldiers, and paramilitaries in Thailand torture captives in a variety of different circumstances. Unlike in the preceding case, the accounts of many, the preceding case being the one, of course, that I've just mentioned to you, the accounts of many, if not most of these acts of torture, and by torture here I mean torment, purposely delivered onto a totally dominated person in the name of a public authority. Most of these are not heard in Thailand's courtrooms. They're not heard for a variety of reasons. These reasons include that the tortured person may not say anything about their torture for fear of repercussions, or they may say something but settle the matter without it ever getting into a courthouse, or they may die while they're being tortured, or die after being tortured, and nobody else speaks up for them. Today, I'm not going to be concerned with the unknown number of cases of torture that judges in Thailand do not hear, but I'm going to restrict my discussion to some of those that do and in fact have found their way into Thailand's courts. If evidence of torture is brought to a court in Thailand, then what happens? What, to narrow this question, do judges decide in matters of torture, of alleged torture? On what grounds do they decide? And to narrow the question still further, how do they account for torture and with what effects? And by effects, I mean broadly legal and otherwise. In response to these questions, I'm going to try to outline very briefly a jurisprudence of torture, a theory, that is, of the relation between the practice of torture and its interpretation in state law courts in Thailand today. In doing so, I'm taking as a prompt, a starting point, if you will, Austin Surratt and Thomas Kern's proposal from some decades ago, 1991 in fact, for a jurisprudence of violence that attends to how the logic of violence surpasses legal rules. And I'm going to do that by inquiring into the experience of physical state violence and the law's response to it among people in a particular time and place. So that's to say, and to that end, rather than start as lawyers and some philosophers want to do with the absolute prohibition on torture and proceed from that point to debate questions about what circumstances, if any, might justify its use. Here I'm starting with practices of torture and working towards the relationship between the tortured person and the state whose officers who torture by attending to how courts in Thailand make torture a category of state violence that is knowable to law, and in so doing, I think, attempt to render it harmless to the state. They attempt to keep it, as Robin Wagner Pacificae has written, and this I should add is a piece of writing to which Tyrrell first drew my attention. In this piece on lethal state violence, Robin Wagner Pacificae has referred to it as essentially innocuous. So the problem for me then is, how does this quality of torture as being or becoming innocuous through a jurisprudence in Thailand come into a condition of being, and then what are the implications of it? What are the knowledge implications? What are the political and legal implications, broadly conceived? And I say broadly conceived because I'm speaking to one fairly narrow part today of a larger project. This is one piece of work among the output of some 16 months of field work that I did in 2018 and 2019, funded by a grant from the Australian Research Council, looking at torture in both Thailand and Myanmar. In Thailand, together with a research assistant, Pimchat Permpun, who at that time was a graduate in political science from Chulalongkorn University, and at the time was studying for a law degree, which she's now completed. Together with her, I assembled an archive of 34 recent cases in which judges in Thailand heard detailed accounts of torture. I, or rather we, Pimchat and I, assembled the cases by working in and among groups in Thailand that are responding to state violence there. And I'm sure that these are groups that many of you already know, and perhaps many of you have interacted with or worked with. They include, in particular, the Cross-Cultural Foundation and some of its affiliates, Thai Lawyers for Human Rights, and United Lawyers for Rights and Liberty. In addition to working with and through these organizations, we also obtained case records from some other sources, including some that we got directly from the Office of the Supreme Court. All of the cases that we documented occurred or were referred to the courts and heard in court during the last decade. And all of them concern torture that has occurred in the last 2 decades. Some of the cases of torture were cases that occurred in periods of elected civilian government, and others during periods of military dictatorship. Of the 34 cases, half of them were at the time of fieldwork either ongoing, they hadn't yet been concluded, or they had been concluded without the judges actually deciding on anything. The judges had not in fact adjudicated. The case had been resolved administratively or withdrawn or otherwise. So in this talk, I'm actually going to restrict myself then to the remaining 17 cases in which the courts actually did adjudicate. We have a record of decisions by judges in response to a greater or lesser extent, the accounts of torture that they heard. And in these 17 cases, there were a total of 50 men and boys, teenage boys, who alleged that they had been tortured. These cases, just to conclude my account of the material with which I worked for the purposes of this research, cover some 3,500 pages of court, police, and administrative records. At least that's the amount of documentation that I gathered up as part of the research. There's a great deal more than that on these cases. And additionally, video footage and photographs taken by police officers in some cases, as well as the lawyers' handwritten case summaries or typewritten case summaries. And in some cases, online print and television news reports. We also took a lot of notes from conversations with lawyers and parties to cases over the 16 months, and notes on courtroom visits like the one that I described at the outset of the talk. Just to give you a sense of the cases before I proceed to the jurisprudence. In 5 of the 17 cases, the tortured men were appearing in court as criminal accused, and they made the statements that they were tortured in their defense. That's to say that they were offering up accounts of torture in order to rebut the claims of police that they had committed criminal offenses. In 2 more cases, they'd appeared in court because the police had alleged that they had falsely claimed torture. In other words, they had had counter-complaints lodged against them by police officers over allegations of torture that they had made. 5 of the cases were post-mortem inquests, in other words, that the tortured person had died. And in 2 cases, the tortured men brought cases against the police after the public prosecutor had declined to do so, including the case in Ratchaburi that I mentioned at the outset. The remaining 3 cases were in administrative courts, and those courts hear compensation cases against state agencies. Of the 17 cases, 9 of them pertained to violent conflict in Thailand's south, in the deep south, where, as I'm sure you all know, soldiers, police, and paramilitaries have since 2004 tortured captives held in counterinsurgency operations, often under the terms of martial law, and since 2005, the emergency decree. This is the area of Thailand where, on human rights defenders' accounts, torture is practiced routinely, and arguably it's the only part of Thailand where there are established torture chambers, i.e. sites where torture is routinely conducted. One human rights defender from the far south, who I spoke to in the course of this research, himself a torture survivor, who is doing a lot of work there, estimated that, and he estimated this just in conversation in March 2018, that among some 200 former captives with whom he had worked from 2016 to early 2018, soldiers, police, and paramilitaries had tortured around 170 of them. So that's to say that the Deep South is a place where torture is widespread by these accounts, and we may conclude relatively more frequent than in other parts of the country. But if there exists a deep divide between the far south and the rest of the country politically, to an extent legally in terms of the emergency regulations that have operated in that part of the country, and therefore also in terms of the types and extent of torture that's practiced there, I think it's nevertheless factually correct to say that state officers practice torture in a range of different conditions and a range of different types of cases in other parts of Thailand as well. And that's what I want to try and illustrate in the time that I have available to me today by way of this jurisprudence of torture. So let me now turn to the jurisprudence of torture and try to outline it to you. The jurisprudence comprises of two interpretive layers. The first layer concerns how judges themselves interpret accounts of torture so as to be able to decide something, right? As I've already alluded to, what they're trying to make a decision about will vary depending upon the type of court that they're in and the matter at hand before them. But nevertheless, the role of the judge is in some way or another to adjudicate on a matter before them. And so this is the first layer of the jurisprudence. In this layer, we have questions related to judicial practices that produce knowledge about torture and how the practice of torture in particular and state violence more generally is or is not addressed through knowledge production practices of courts in Thailand. The second interpretive layer in the jurisprudence concerns what I myself have inferred about how judges in Thailand have created and organized knowledge about the practice of torture from observation of cases in which facts about torture have gone onto the court record and have been among judges' deliberations. There are then, with these two layers in mind, three basic principles that guide the jurisprudence. The more I think about them, the more I'm inclined to think that they do correspond broadly, although in some of their particulars they differ perhaps, to Stanley Cohen's types of denials for state violence. And here I'm going to refer not directly to Cohen, but to Ginny Loganita, my colleague who has done a lot of work on torture in India and wrote a fascinating comparative study of torture in India and torture in the US and in the American Imperial Program around the world. And in that particular study, the comparative study, she draws on Cohen to refer to three types of denial as follows. One, literal denial, i.e. parenthetically, that there's no torture. Two, interpretive denial, i.e. something happened, but it was not torture. And three, implicatory denial, i.e. it happened, but it was necessary. Situating these denials in terms of the research I did on torture in Thailand, the three jurisprudential principles that I'm working with here taken together, let me offer them as an aggregate first and then disaggregate them, might be expressed as follows. And perhaps I say might because in response to critics' interventions, I continue to play with the terminology here. They might be expressed as follows anyway, that an allegation of torture ought to come with evidence of physical bodily injury for which no alternative explanation exists. That's one. And that if proven, then torture ought to be excused if done in the name of state duty. That's two. Or if it cannot be excused, then elements of the torture situation ought to be subtracted from the case so as to diminish its significance and minimize harm that it might cause to the state. That's three. So let me just repeat them. One, that an allegation of torture ought to come with evidence of physical bodily injury for which no alternative explanation exists. Two, that if proven, then torture ought to be excused if done in the name of state duty. And 3, if it cannot be excused, then elements of the torture situation ought to be subtracted from the case so as to diminish its significance and minimize harm that it might cause to the state. In the remaining time, I'm going to expand on these 3 principles with reference to the cases that we documented during this research and offer a very short conclusion. So the first principle of the jurisprudence is that without physical bodily injury, no allegation of torture can or should be sustained. This principle aligns with Darius Rejali's hypothesis in his global survey of torture practices, with which I know some of you are familiar, and the transmission of those practices, in which Rejali says, quote, "Public monitoring leads institutions that favor painful coercion to use clean torture to evade detection," unquote. Now, by clean torture, Rejali means that torturers today do not purposefully leave obvious marks of a sort that might once have been inflicted deliberately as a manifestation of sovereign power on the body of the subject. So it's not to say that clean torture is in fact without any bodily marks, but that bodily marks are not deliberately a part of the program of torture, such then that evidence of torture be borne for all to see on the body of the tortured. And I think that the cases of torture in Thailand that we documented in this research support this hypothesis. Lawyers, doctors, journalists, and human rights defenders there, as I'm sure many, if not all of you know, monitor army, paramilitary, and police practices often quite scrupulously in some parts of the country. Nowadays, relatives of captives and detainees come to police stations, army camps, and jails with mobile phones, taking pictures and video of cuts and bruises, swelling, bloodshot eyes, and broken teeth, which they post online and they relay to lawyers to use as evidence in court cases sooner or later. So all of this encourages military, paramilitary, and police torturers to use clean techniques. Where they don't use clean techniques, judges might observe and then record physical bodily injuries, which could at least undermine a police case and might in fact rebound unfavorably on the officers who have tortured the person or persons. In the Brachimburi case that I mentioned at the outset, for instance, judges who first heard the details of torture also saw photographs of bruises on the former captive's face, on his chest, on his stomach and shoulders, and marks from strenuous handcuffing that corresponded with his account. So there was a photographic record that they could refer to for some type of validation, some verification of his oral account. Additionally, a medical certificate that a doctor issued shortly after his release from captivity verified the injuries, and the judges put all of these details onto the court record. In another case of torture that we documented, which occurred in 2002 and dragged on in court for over a decade, judges at a remand court in Ranong on Thailand's the Southern Peninsula called for a doctor to examine one of 2 men who had said that police had tortured them to confess to murder. The doctor saw what appeared to be 10 burn marks on one of the men's genitalia and another on his tongue. This evidence was unambiguous enough for the tortured men, one of whom was previously a local government official, to bring a criminal case against the police, notwithstanding that the judges in the meantime still convicted the men of murder, and as well as a 3rd accused person. So these are 2 examples of where photographic evidence or evidence on the body of the person, which is quite unambiguous, leads judges to proceed to take the complaints seriously and then think about the implications of them for the court process. But there are many cases in which there's physical evidence of torture that don't get as far as in those 2 cases. And what we see is that very often, or at least certainly among those cases that I looked at and others that which were recounted to me anecdotally, but I didn't generate data on, torturers very often in Thailand do not need to be scrupulously clean. To talk about clean torture then is in some minimal sense. They only need to be clean enough, if you will. A torture doesn't have to be spotless. It just has to ensure that judges can overlook bodily injuries that are not sufficiently impressive or not sufficiently distinctive enough that there's no explanation for them other than that they were as a result of torture. They might also overlook injuries that are not documented very soon after torture has occurred or that appear superficial in their character. So where physical evidence of bodily injury is weak or imprecise, judges don't need to bother to register the fact that they've heard stories of torture, let alone ask after its possibility. Or they can register the fact that they've received the testimony, but simply decline to comment on it, to note that in testimony an allegation of torture was made, but do nothing more with it than that. And that's what two judges at a provincial court in the southern province of Trat did when three men and the wife of one of the men told of how soldiers tortured the men to confess to a fatal bomb blast that ripped through the marketplace there in May 2014, just a few days after the military coup d'etat of that year. The three men had testified that soldiers hooded them and drove them long distances to various parts of Thailand's central provinces and to an army camp in Chonburi. They told of how the captors repeatedly suffocated them with layered plastic bags, beat them with various instruments, threatened to kill them by pushing them from moving cars and drowning them, electrocuted one of them, pushed the head of another one of them under the water, and held his wife hostage and told her that she was never going to see her husband again and that she also was surely going to die. Most of the techniques that they used left no marks, but the beatings and the handcuffing did. And these injuries are captured indistinctly in photographs taken some time after the torture occurred. Now, the judges heard lengthy and graphic accounts of torture. What I've re-narrated to you is just a short summary of the details that they heard. And they put them onto the record in the manner that, as again, I'm sure most of you, certainly many of you appreciate, occurs in Thailand, such that the judge is responsible for re-narrating what the testimony is of the witness in court. That it is not a verbatim record of the witness, but rather a re-narration by the judge that goes onto the court transcript. So the judges did in fact re-narrate these details of torture. They summarized them in their verdict, and yet they said nothing of them when it came to the work that they had to do as interpreters. Instead, they preferred other grounds on which to decide the case. They stressed that there were no eyewitnesses or material evidence that linked the accused to the crime. And soldiers who had investigated and detained the men hadn't even turned up at court to testify. So the judges, in fact, did acquit the men, but they acquitted them because the prosecution case was shabby. The question of whether the confession of one of the accused was obtained by torture was left unanswered. So these cases all relate to bodily injuries. Under Section 295 of Thailand's Penal Code, bodily harm, though, can either be physical or mental. In 3 cases documented among those that we worked on over the 16 months, where lawyers brought evidence of mental bodily harm caused by state officers' torture, in 1, criminal court judges completely disregarded it, and in 2, administrative court judges acknowledged it, having accepted the complainant's versions of events because of evidence of physical bodily injury caused by sustained violence. So that's to say that in that case, because there was also physical bodily injury, therefore the judges were prepared to listen to or take seriously an account also of mental injury. The first of the cases, though, was the one in Prachinburi that I mentioned already, which I keep coming back to in order to anchor my discussion. And there, a clinical psychologist opined that the young man who had been tortured was in fact suffering post-traumatic stress disorder. But for reasons to do with how the case reached the trial courtroom, the lawyers for the tortured man had no opportunity to call the psychologist to amplify the contents of the report in court. The judges said that they had everything they needed on file to decide, and they cut the lawyers off when they proposed to review facts on record by, among other things, bringing the psychologist, telling them, this is the judges speaking, that they were wasting the court's time. And their ruling makes no mention of the psychologist's report. In those two other cases in the administrative courts, it was in fact doctors from the International Rehabilitation Council for Torture Victims who did the assessments. And in their view, in both cases, the men that they examined had been grievously tortured and were experiencing trauma consistent with the accounts that they'd offered up. The judges acknowledged that the reports had been submitted, but they didn't comment in any detail on the specialists' reports. Notwithstanding, they did award damages for both bodily and mental injury in view of the sum total of the physical and circumstantial evidence received. So to iterate, the jurisprudence in each of these cases then recommends that torture be clean enough that judges can overlook bodily injuries. But where physical bodily injuries are excessive and sometimes fatal, then the second principle of the jurisprudence comes into effect, and that is that physical bodily injury is not proof of torture unless no reasonable alternative explanation for the injury exists. In other words, we accept that there's an injury, but might it have occurred due to something other than torture? Now, this principle puts the onus on the captive, in the cases that I observed, on their family or their friends or the lawyer to record physical bodily injuries as quickly and as thoroughly as possible and as soon as possible after the torture. And of course, it depends on the possibility of doing just that. In the Prachimburi case, that possibility existed. The police let the teenager go home after torturing him. His father, quick thinking, took photographs of his body and rushed him to the hospital. The next day, they went and made a complaint at another police station. So all of this went down on the record. Now, the accused police, of course, still said that the injuries recorded were nothing to do with them. But because they were recorded so soon after the young man had left captivity and were consistent with his account of what had happened to him, the judges said it was implausible that the police had had nothing to do with those injuries. Nevertheless, their verdict made no reference to torture where it was unsupported by clear evidence of physical bodily injury, as I said already. It neglected to mention the psychologist's report. It neglected to mention the account by the survivor of torture that the police had used a plastic bag to suffocate him. It neglected to mention the alleged threats to kill him and dump his body on a nearby mountainside. For the judges, physical bodily injury alone counted as evidence, and because that injury was consistent with and proximate to the narrative of torture and the time and place in which that narrative had occurred, it was reasonable to consider it. Where someone dies due to torture while in state custody, the extent and character of physical bodily injuries are put on medical and sometimes on post-mortem records. However, these records can work not to deny that torture has occurred, but rather, as Tuul Haberkorn has put it, to at once assign and refuse to assign simultaneously responsibility for what has happened. And by way of one example that I have among the cases that we documented along these lines, a doctor who completed a death certificate for a man in his 30s who police in 2015 held in captivity in Nakhon Ratchasima, that's of course in the northeast of the country, on a drugs charge, recorded the primary cause of death as severe blood leakage into his brain caused by blunt head injury. In court, the doctor testified that the fatal head injury seemed to have been accompanied by multiple blows to his head that could not have been caused by a fall and the tatani hitting his head on a hard surface. In other words, those injuries were not accidental. They had been inflicted. The provincial court judges concurred with the doctor that the deceased had been tortured or assaulted while being kept overnight in the police lockup, but they also agreed with him that the specific cause of death was that he had hit his head while attempting somehow to evade seizure, as the police had said. They concluded that it was not apparent who had caused the injuries to the rest of his body. In other words, they assigned, but they declined to assign responsibility for what had happened in that police lockup. This brings me to the third principle, the last of the three principles in the jurisprudence, which is that where physical bodily injury is proof of torture and no alternative explanation for the injury exists, other than that a captive was tortured, then torture should be excused in the name of state duty, or elements of the torture situation should be subtracted from it so as to keep torture innocuous. Now, again, it's Turul Haberkorn who's offered the keenest interpretation of how this principle works in torture cases in Thailand through her invaluable reading of the files on Imam Yapa, who died in a police truck parked at a military post in the compound of a Buddhist temple in Yala during 2008. And in her reading of the court order from the post-mortem inquest, Turul points out that while recognizing that Imam Yapa had died in military custody of fractured ribs and a punctured lung caused by assault of unspecified on-duty soldiers, judges in the Narati Wat provincial court repeatedly emphasized that the officers were performing state duties. In doing so, they effectively inverted the international legal prohibition on torture. A necessary element of the crime in international law is, of course, that the offender is a public official or someone acting on their behalf. Furthermore, the crime can never be justified. It's a jus cogens norm, a preemptory norm from which no derogation is permitted, etc. Yet on Haberkorn's interpretation, for the judges in Thailand examining the imam's death, torture could be excused precisely because the torturers were state officers who were doing their duty. The obverse, a logic, if you will. So, where physical bodily injury exists as evidence of torture and no alternative explanation for the injury exists other than that a captive is tortured, then judges in these cases that we looked at in this research, seemed then to proceed along a logic such that they tried to diminish the elements of the cases, to subtract things from the cases, to reduce the number of state officers and institutions responsible, to isolate one or two agents or agencies as liable, and in so doing to minimize then overall potential harm to the state. Let me return again to Prachimburi to remark on how this method works. There, lawyers for the tortured teenager initially brought the case against 7 police officers. Judges hearing the allegations subtracted 3 police officers from the number for a variety of reasons, but overall saying that these 3 had no seeming direct connection to the act of torture and therefore couldn't be held responsible. Subsequently, 2 more were subtracted, these being the 2 who actually admitted to having observed the torture taking place, but denied that they themselves were physically putting their hands on the young man at the time of his torture. And in exchange for their admissions, the plaintiff agreed, along with the court, to remove them from the case. So in this way, we go from 7 accused down to 2 accused. Now, this is even though the torture occurred in a room in a district police station in office hours, in daylight, with many policemen present, with other people in custody, with others passing through or nearby the torture situation. Nevertheless, via this method of deduction, we see a real-life torture situation involving many people in a specific institutional setting being reduced to a kind of parody, akin to those fictitious torture scenarios of philosophers or Hollywood screenwriters, in which 1 or 2 goal-oriented officers work efficiently, absent of all of this other stuff, absent of the groups of people that are always present in real-life torture situations, evacuated of the institutional arrangements in which torture takes place. In the Ranong murder case that I mentioned earlier on in my talk, torture was the only available explanation, as I said already, for the burn marks on the genitals of one captive. The question there was not whether the police had tortured him, but who and how many among them had done it. The lower court judges recorded and acknowledged in that case that many police working in teams from at least 2 different stations, as well as from a regional command, had participated in the abuse of the captives. But the Supreme Court said that it was not possible to firmly identify most of the accused. The fact, the court said, that the officers' names were on the police records as investigators was not proof that they were among those who had abused the men. And in an interesting turn of fate, they insisted that the only 2 people that they could hold responsible were the commanders of the investigating units, partly for reasons of command responsibility, but also because the tortured men could clearly identify them as the commanders in the torture situation, even though the Supreme Court agreed that these commanders had jointly with unspecified others committed the crime. Lastly, I'll just note, given that I'm out of time, I won't go into it, but I think it's worth just noting that, and we could take this up for discussion subsequently if you like, in the administrative courts, lawyers for tortured men or their families bring cases, as I already mentioned at the outset, against state agencies, not against the torturers themselves. Judges in administrative courts, more than the other courts, have left their doors partway open to survivors of torture or families of deceased, who in these cases will be seeking financial redress. And the courts have actually been the strongest in insisting that they do have jurisdiction to, they have authority to order state agencies to pay compensation, and that they do have that jurisdiction even where state officers torture captives without authorization, as it were, of their superiors. Nevertheless, in deciding who pays, they too, among these few cases that I have seen so far, seem to adopt a logic of reduction and isolation of the number of liable parties, such that, for instance, in cases from the far south of Thailand that occurred under the emergency decree, not the police force or the army whose officers in fact tortured the people who brought the cases, but the Prime Minister's office, which was responsible for making the decree, for declaring emergency, that office has been held financially liable exclusively. So to recap and conclude, the jurisprudence of torture is constitutive of state violence in Thailand because it acknowledges and retroactively queries many of the facts of torture without challenging the practice or, for that matter, the institutions that are responsible for it. Rather than prohibiting torture, the jurisprudence conditionally accommodates it. It guides judges, when in doubt, to come down on the side of testimonies and evidence from state officers rather than from the side of survivors of torture and their advocates. It nudges judges towards decisions that favor captors over their captives and state officers over, if you will, state subjects. Nevertheless, in this regard, or for precisely these reasons, it is then also jurisprudential, inasmuch as it guides, but it does not obligate judges to err on the side of torturers and against those whom they have allegedly tortured. And at the outset of our discussion, Tyrrell referred to my work, my ongoing work on Myanmar, which I'm sure, as many of you will appreciate, has taken up most of my spare thinking and emotional time in these last few months. But in relation to that work, I think there's some interesting possibilities for comparison that between Thailand and Myanmar that I haven't yet fully worked through, but I will hope to do at a later date. And the comparative point, I think, of interest here as a scholar of courts under military dictatorship in Myanmar past, and unfortunately, again, it seems to be almost inevitably in the future as well, that in contrast to what we see in Thailand, there is no jurisprudence of torture in Myanmar to speak of. There is an abundance of torture, but what we encounter is a condition in which courts are so diminished that they have very little choice but to comply with executive directives. Judges in Myanmar are enlisted to do the bidding of others. In their setting, it's the policeman or the prosecutor, not the judge, that dominates the courtroom. And so under those circumstances, I think there's scant evidence of the kind of jurisprudence that exists in Thailand. So for all of my misgivings about it, as you'll have gathered from this presentation, nevertheless, I think at least to speak of a jurisprudence is to indicate that judges are in a position, in fact, to decide. And so judges in Thailand, then, we might think of as being not so much enlisted as in the case of their counterparts in Myanmar, but enrolled in the work of interpreting, not merely implementing facts about torture in Thailand. And they're needed to do that. They're needed, in fact, to contribute their expertise, their technical skills, of which they are on the accounts of people like Duncan McCargo in his most recent, very important book, Rightly Proud. That technical skill is necessary in order that they reach a desired result, an appropriate result, one that protects the state from harm, but does it in formally correct terms. And it is then for this very reason that I think we can speak of a jurisprudence of torture in Thailand, a jurisprudence of torture such that this category of state violence finds its expression in legal idiom and therefore its place in the arrangements of the state in Thailand. I thank you all very much for staying with me throughout the presentation. I have an epilogue of sorts, which would return me to the beginning of the presentation, which, if anyone is interested in it, I'm happy to refer to, but cognizant of the time, I'll leave it presently, and I look forward to your questions and comments.